opponent.
I think that's right. Yes, right.
Yes.
But I'm summarizing and I'm confabulating two different things. His delusions were that he was being beset by all sorts of things that were coming after him. He was afraid, that kind of thing. And then he armed himself and he thought these people were part of some conspiracy to harm him. That's what I'm talking about.
That people had been coming in and leaving his toilet seat up.
That was part of it, yes.
But no threats of harm to him.
He was perceiving these as threats. This is what I get from his writings. He was perceiving these. The man was having delusions, and he was talking about perceptions of protecting himself, that he had enough. That's why he went to the White House to talk to President Trump, that sort of thing.
The instruction does not say that a person has to exercise reflection and sound judgment.
No?
So in this case, there was proof, was there not, that he did exercise judgment regarding his actions.
There was proof from the government that would have supported exactly what you're saying. I suggest to you, sir, that because of his delusions, you could make a viable argument that this judgment was impaired because of his delusions.
And the defense put on proof that not only was it impaired, that he was, in their opinion, incapable of appreciating the wrongfulness of his conduct, correct?
That went to the affirmative defense.
Right.
It didn't go to the expert opinion that you said is required for diminished capacity. That could have been asked about that. I'm saying a reasonable lawyer would have asked a doctor to opine on that and put on evidence of that. That's what I'm saying. And go to the very thing that the judge charged the jury. Of course you all had evidence of reflection and judgment, but I'm suggesting that a delusional person might not have been capable of reflection and judgment because of his mental problems. That would have been a jury decision.
Okay. And that would have also been subject to vigorous cross-examination.
It would.
And pointing out the things that Mr. Reinking did to prove that he was premeditated.
Absolutely, there was proof of that, which is all the more reason the defense was incumbent on the defense to counteract that, because the burden of proof is on the government, not in insanity. That's why I keep coming back to this thing. Insanity is that the burden is on the defendant. Diminished capacity, the burden is on the state. If you negate that or raise a reasonable doubt about premeditation, then you don't get a conviction. That's what you do with diminished capacity. You create a reasonable doubt by putting on evidence to counteract it. That's how that works. And that is very effective.
In cases primarily where there are bench trials in the reported cases, correct?
Right.
The question of the defense attorneys and what you testified about what they should or should not have done with respect to jury requests. I believe that the way you testified is more of saying in your lane, but would you agree that it is incumbent upon the trial judge to be the one to determine what the jury charge should be?
Yes, sir.
And that the trial judge is tasked with having to give a complete charge, jury instruction.
Yes, sir.
Okay. And which instruction, again, should the attorneys have made up their own, submitted?
Okay. On the acquittal first defense, or whatever that is, there should have been an objection to that, and then maybe some special request to talk about the proof being overlapping or whatever. That's one of them. Then there should have been a special request or objection there should have been a special request on this thing about that you can consider, well, it should have, you're asking what about the special requests
No,
or as
and-
opposed to the objections?
Would you say
Again,
the
I'm confused.
one first, that you said they should have made a special
They
request
should have made a
for-
special request to alter the instruction on the acquittal insanity thing. That should have been done.
Have you seen any case where such an instruction has been proposed to a court?
No. But, I mean, but no instruction like that would be, the instruction would have been to alter the instruction that the judge gave, is what I'm trying to say. Because it's not the law. I don't know you would make an instruction on that. I mean, I'm confusing myself as to what I'm saying. There is no law on that, therefore there wouldn't have been any instruction necessary.
And that's my point. So you're saying they should have been the first to come up with this?
No. An objection requires two things, that you stand up and object, and secondly, if appropriate, that you file a countervailing special request. That's what the law is in Tennessee. That's the best way to preserve the issue. That wasn't done.
The
The
motions
reason for
and
that
limit,
is the law is that an incomplete an incomplete instruction may not be erroneous, but if it's not given a special request to make it more fulsome, then there's no error. That's what the problem was.
so the instruction as given may not have been objectionable, correct?
It was objectionable.
And would have been an issue of first impression?
To my knowledge, it would have been. But what I'm saying, General, is not only, if you want to preserve an issue, something like that, you not only object to it, as you then do the best you can to file some countervailing special request, if you can.
Okay.
Would that special request have been, just don't give that part of the instruction?
Well, an objection would have been to object to it. Then I think, then if you could have said, given that, then you can consider, you still can consider the mental stuff as it relates to guilt or innocence or something. I'm sort of flying here. But, I mean, you're dealing with something that's not, that's the only thing I'm suggesting. If there would have been any duty to file a special request, it would have been to mitigate that instruction of some sort. That, I'm only saying for record preservation purposes, that's the best practice to do it. So then you've clearly preserved the issue. But it sufficiently would have been, it would have been sufficient just to object to it, in my view.
I was just making clear that you were saying they had an affirmative duty to prepare an alternative jury instruction under the state of the law as it existed at the time of this trial.
I think that's fair, yes. I think that is. To guarantee that you preserve the issue is what I'm trying to say. I mean, you're getting into the minutia of special requests and objections, but I would say that's the best way to do it on something that profound, sure.
And correct me if I'm wrong, but cannot objections and/or deficiencies or
Right.
in the jury charge be raised at a motion for new trial without having been preserved by an objection?
Okay, some of them can, but not all. Where the jury instruction is erroneous, then there's a distinction between erroneous instructions and instructions of omission. And as I sit here, I can't remember one, but typically you can raise those things in motions for new trial, but the better practice is to raise them on the spot.
And so the question of whether this was erroneous or
Right.
an omission or commission is unsettled.
I think to answer your question, if something that profound, if it's unsettled, I think you would have had a duty to do it. The law may be that when these lawyers raise it now, that that's sufficient. And I'm not here to debate that issue. I'm just saying that you should have raised it then, to try to keep the jury from ever having, I mean, a new trial is a terrible result. You don't want to have that. So you want to do the best you can to protect your client at the time. That's all. Whether it was adequately preserved or not is not something I can give an opinion on at this moment.
Okay. Be fair to say you have not submitted any proposed jury instruction on this issue to any court anywhere?
Not in 51 years, no, sir.
Okay. Now, with respect to the witness from the mental health witness being cross-examined about the defendant appreciating the wrongfulness of his conduct and an indication of his appreciation for that being his requesting an attorney.
Yes.
You are, that there is law that supports that proposition, that the trier of fact can consider that as an issue or as a factor in determining whether the defendant appreciated the wrongfulness of his conduct.
Are you asking me, or
Yes, I was asking, are you aware that there is,
what case is this? I'm saying that the Supreme Court has said that you can't. Is that what you're asking me?
in State v. Holder, I believe you referenced Holder
I
in
did.
your direct testimony.
I think so.
And in that case, where on the appellate court, his refusal to sign his statement followed by a request for an attorney as indicative that he knew he was in trouble was an indication of appreciating the wrongfulness of his conduct.
Well, if the court allowed it in and then nobody objected to it and then there was nothing there, yeah, of course.
And you're saying in this case, though, the defense should have,
Let me stop. If
Yeah.
if in that case the lawyers didn't raise the issue of the constitutional question, is it evidence? Yes.
Yes.
But is there a way to avoid it by raising the constitutional question? Of course. Simply because the lawyers didn't do anything and they let it in and this appellate court said, sure, that's fine. That is the law. That's correct. But what I'm saying is, you know, if they didn't read him his rights or whatever it is, and then the confession becomes inadmissible. Just because there's law that supports what you're saying doesn't mean that it's admissible. The fact that a jury could rely on unobjected to testimony to find wrongfulness, that is the law. If it's objected to, then that's a different analysis. And I'm saying that's what should have happened here.
I just want to clarify that there is law where that language has been used.
I completely agree. In the absence of objection, that is permissible. That's what that case holds.
And just for State v. Blaine Scott Holder at 15 Southwest 3rd, 905, which was a Court of Criminal Appeals opinion, permission to appeal denied. So from that standpoint, the state, under the law, was allowed to ask the question. To the medical, the psychological
Okay.
witness.
I'm not suggesting that the state committed any error by asking the question. My analysis is so, in other words, was that something like if the general had said, did he pass a polygraph test or something like that? Of course, couldn't have even asked that question. But under the state of the law, could he have asked a question about he didn't, he asked for an attorney? Under the state of the law at the time, as it is right now, that was not an illegal question like asking about polygraphs. The state didn't commit an error. I'm not suggesting they did. That was advocacy on their part.
I just want to clarify that part, that we weren't talking about the state asking a question that was totally outside the bounds.
No, it was based on the case law. It was well within the bounds of propriety in terms of being admissible and something that the jury could consider. But it's because of that, now you've likened me to those two cases. That's all the more reason these lawyers should have said, oh, wait a minute, if that's coming in, we'll be filing this motion limited to keep that out. I mean, I didn't think about that, but yeah, that's all the more reason they completely were erroneous in failing to object to that pretrial, without a doubt.
And if we had had a motion in limine hearing, the court may well have said, yes, you are allowed to ask that question, and I will give a limiting instruction.
The judge could have ruled that. I'm not here to debate what the judge might or might not have done.
Understand.
I'm not here. What I'm suggesting is the judge had let it in the face of the Wainwright case, then it would have been a violation of it would have been a violation of the Wainwright case. The problem was, in the absence of that case, the judge told the jury that you can consider it for its effect on the wrongfulness, okay? Which is true, assuming that there's no constitutional violation. Because the lawyers never raised the constitutional issue, the judge was telling the jury about what the state of the law is in Tennessee, okay? That's right. The prosecutor was right. The judge was articulating that. But the problem was the lawyers just sat there and did not complain about it beforehand when the Supreme Court of the United States says that's not coming in. It's like a Fourth Amendment violation, General, or a Sixth Amendment violation. If you just don't object to the confession or the search, it comes in. But you have a duty to object on constitutional grounds. And these lawyers did not do that. And when they did, they didn't have the Wainwright case to avoid that limiting instruction, which was devastating to the defense. That's why the courts rely on it, General. They use that exact evidence to find an absence of wrongfulness or the presence of wrongfulness. That's exactly what they did. That's all the more reason why it's harmful. The very two cases you cited.
And the defense, though, did object
They did.
contemporaneously.
They did. Well.
And the
look,
judge.
General, they objected. In my opinion, it was too late, and the limiting instruction that they didn't object to did not cure the problem. It made it worse. And rendered the Wainwright decision ineffectual. It was like it was never decided. That's the problem here. It should never have been, they should have had that case ready to go, and maybe not a motion limiting, but be ready to articulate that. That's the problem. That's why it comes in. The very evidence that the courts used to uphold an insanity verdict is what the state relied on to convict this man. That's the problem.
But it was not the only evidence the state relied upon to prove the defendant appreciated the wrongfulness of his conduct, correct?
No, sir. It was one of the factors that the state argued in closing argument and the appellate courts relied on in other cases. It was a significant piece of evidence.
I'm sorry.
It was a significant piece of evidence, in my view.
You say the attorneys, we've already touched on this a little bit, should have had his competency reevaluated.
They should have, is my opinion now.
And is that based on anything that you saw during the time that you watched the trial? Because I'm sure they panned over on the defendant.
What I saw of the trial, I did not see the defendant. All I saw were the witnesses, some of the doctors being cross-examined. That's all I saw when I watched the trial.
In this case, Mr. Bruno, Mr. Evans, and Mr. Haskell put on the defense of insanity per statute and in accordance with the evidence that gave the court the affirmative defense.
They
Correct.
did.
And would you agree, you don't have to, but that the issue of a severe mental disease or defect was not contested by the state?
That's true.
And so that the trial literally came down to, could Mr. Reinking appreciate the wrongfulness of his conduct?
That's the way that it was litigated. There was no litigation that I recall on the nature of his conduct. I think there's been some expert testimony here in the motion for new trial. But you're asking me, as the trial developed, based on the record that I read, yes, that was the issue.
Okay.
Correct.
And I know over the years, you and I have had conversations about nature of conduct and how that is very rare for a person not to appreciate nature of conduct, even with a severe mental.
It is rare, but it is certainly possible, depending on the nature of your delusion. I mean, the classic example is where the man squeezes a lemon, but it's actually his wife's head. He doesn't understand the nature of what he's doing. If you have a misperception of who the victims are, they're robots or they're part of some conspiracy to harm you or whatever, then you start to blend the wrongfulness and the nature. But generally speaking, it's possible, depending on the proof. And again, I didn't have the benefit of the neurological problems that a man apparently has. Was the only litigated issue. That's true.
And he had not to dwell on the nature aspect, but in this case, Mr. Reinking knew he was shooting people.
I would say that there's evidence that, yes. I would have to say that based on the record I read, yes.
And that there was evidence to prove that he was shooting a weapon and knew that it was a weapon he was firing as opposed to a football.
I think there's evidence of that to prove intent. The intent to kill was proven here abundantly, yes.
I'm talking more about the nature of what he was doing, that he knew he was shooting, he knew he had bullets in the gun, and he knew he was shooting people.
Okay. If you can find the nature, and the Tennessee case law is not as well developed in Tennessee as it is in other jurisdictions. In other jurisdictions, there's a much more expansive definition and application of nature than in Tennessee. Tennessee uses traditionally the nature as we've discussed. Can it be expanded? Sure, if the evidence is, if the psychologists and psychiatrists would get into that based on the type of delusion the person has. Is that possible? Yes. Under this record, that was not litigated, if that's what you're asking.
And that's why I was asking about, that is very rare in Tennessee.
In Tennessee, it is. It's not very well developed. I will say this, in the two cases I've had where I've had acquittals by reason of insanity, they were agreed to because the defendant misperceived the victim as being robots or not their loved one or whatever. There was a total misperception of what they were, who the victims were, but they weren't even real.
And you say that there are cases, there are instances where the state agrees and
Yes.
literally we have a bench trial for the court to find a
Right.
person not guilty by reason of insanity.
Yes, that's true. That's happened to me. General Norman and I had one like that. Terribly unfortunate case, but the state, yes.
Yeah.
But that was a case where the person did not recognize the nature of what he was doing. He was so delusional.
And we have also the ones of the God-directed.
Right,
as
you're
in
talking
Mr.
about the
Kelly,
ones where God told me to do it, that kind of thing.
and that would be Mr. Kelly,
That would be Mr. Kelly, but the state didn't agree on that one.
as the state is entitled to do.
That's true.
And correct me if I'm wrong, the proof of his appreciating the wrongfulness was that a statement that he knew it was against the law.
That's right.
Okay. And that was sufficient for the case to be
That's right.
affirmed
That's right.
and just so the record is clear, that was a case where he killed his, 6-month-old daughter?
He did. He suffocated her thinking that if the child died, that Jesus would return to earth.
As opposed to here, where we have a man killing 4 people and wounding others
Yes.
because, according to him, the CIA or
Right.
whoever left his toilet seat.
Correct. And I think that under those set of facts, could a jury refuse to accept insanity? Of course. But if you had an appropriate psychiatric evaluation to consider neurological issues, the result might have been different if you consider neurological, the so-called broken brain issues as opposed to behavioral problems. Because the evidence just was not, in my view, the expert testimony, in my view, was not robust enough to have constituted an aggressive insanity defense for all the reasons I've discussed. That's why they needed to have another evaluation, a psychiatric evaluation of him later on. That was necessary here. I mean, the doctors, General, you've asked me that question. The first doctor, Dr. Wood, did not find him insane. The doctor said he was presumptively insane, or probably. And then Dr. Eisen said that he was. So you got like 1.5 opinions from psychologists. My wife's a psychologist. I don't want to denigrate the profession, but I think it's something this profound where you kill 4 people, you want a psychiatrist up there to be, I'm just telling you, that's what you would want.
And having listened to Mr. Bruno and Mr. Evans' testimony, that they felt that the neutral, i.e. court doctors, would be better than hiring someone to be subject to cross-examination. I know I'm not quoting, but you recall the gist of that.
Well-
And that had the state got an expert, it was a, who's gonna do something first?
Let me
Correct.
answer the question that way, because I did review that.
Yeah.
And let me add to what they've said. First of all, a private expert does not mean that the person cannot testify or that their testimony is diminished in any significant way. What they could have done, they could have simply asked the court for funding to appoint an attorney, appoint a psychiatrist, or pick one, or whatever, for funding. And it wouldn't be them paying for it out of their own pocket. It could have been another psychiatrist in Nashville that would have been court-appointed to do that. So I think the idea that if they got another evaluation by some hired gun, okay, I understand the sentiment there, but I'm saying there's ways to completely avoid that. You just ask for funds for an indigent, and if the judge appoints somebody, that sort of thing. That's what you do.
Certainly. My point was, though, in dealing with having that person testify before the jury.
I don't understand the problem. I don't understand the problem with having done that. I'm missing.
Were you not talking about, though, of just under Akey versus Oklahoma, getting funding for an expert that you may or may not decide to use?
What I'm saying to you is, in this particular case, under these facts, you had an absolute obligation to ask the court for funding to have a psychiatrist. If the psychiatrist's opinion is not something that you want to use, then you've done all the Constitution requires. They didn't do it. That's what I'm saying. And so, because they didn't make the attempt, they just didn't do that. They should have.
But would you agree that, at least from their testimony, that was something they discussed and considered?
I would say they discussed it and they was considering it. I would suggest to you that that falls under the objectively unreasonable prong of ineffective assistance of counsel. In other words, if they're gonna call one witness versus another witness or whatever, I can't second guess that. But if you do something that is objectively unreasonable, then that constitutes a Sixth Amendment violation. You may talk about it, but if your decision is objectively unreasonable, then it constitutes a Sixth Amendment violation because you have the evaluation, and then if you decide that you're not going to use it, you've done all the Constitution requires. But to not ask for it, in my view, under these facts, given the time elapsed between the crime and the trial, it was incumbent on them to have asked for an evaluation and asked the court for funding to do that. General, that is my opinion. I understand what they said. I think that their explanation is objectively unreasonable.
And with respect
I
to,
just absolutely think there's no way that that can be. You can't sit there and reject a potential piece of evidence that could exonerate and acquit your client under some notion that the doctor may not be favorable. It just doesn't work for me. I mean, I'll give you a real-life example of that. The Kelly case, the state said, you've got 6 doctors from the defense, all state doctors. We're going to hire one ourselves. And they did.
Yes.
They hired Dr. Martell from California, the most conservative doctor in the country. I don't think he's ever seen an insane person in his life. He evaluated Mr. Kelly and said, yep, he's insane. And he testified for the defense. So it works both ways. I'm just saying objectively, you absolutely had a duty to have this man evaluated again by a psychiatrist, period.
and with respect to Dr. Martell, Dr. Daniel Martell,
Yes.
the state had an obligation to divulge the results of his examination as exculpatory
They did. Yeah.
and did what they were
Yeah.
supposed to do.
Right.
And in this case, so far as you know, the state never had a doctor examine.
I found no Brady violations. The state gave abundant discovery in the case, complete open file as far as I can see. No problem there.
So there was no hide the ball from Mr. Bruno, Mr. Haskell, and Mr. Evans?
None. They had all the balls right in front of them, didn't pick them up, General.
Going back to, just for a moment, the idea of the state/court doctors. They had the opportunity to see Mr. Reinking and evaluate him much closer in time to the actual event
Yes,
Correct.
that's true.
than anyone that could have been retained by defense counsel, trial counsel, referred to them as.
That's true.
And from your experience in dealing, one of the things that the psychologist would say, that the closer in time you can see someone to evaluate them, the better it is for the insanity determination, correct?
That is generally true. The statement you made is generally true. Yes, sir.
And so these were doctors who had examined him, come to an opinion very close in time to when the killing, the shooting at the Waffle House took place, correct?
Yes, sir, that's true.
And counsel was aware of that benefit.
Absolutely.
With respect to the questioning of the doctors done by Mr. Evans, Mr. Bruno, did they bring before the jury evidence of Mr. Reinking's insanity
They did.
in accordance with the statute?
They did.
And the jury, after hearing their cross-examination and all of the testimony, was entitled to render the verdict they did, correct?
Yes. Based on the evidence that was presented to them, yes.
And you're saying, in your opinion, if there was a do-over, things would turn out differently.
It's not what I'm saying.
Well, if the court accredits your testimony and finds that Mr. Reinking should have a new trial because of the ineffective assistance of counsel, it's a do-over, isn't it?
That is correct. It is a do-over, but you didn't, that wasn't the question you first asked me.
Then, can you answer the question that I first asked?
The constitutional question is not, if there's a do-over, is it going to be different? That is not the test. The test here is, if the evidence, if the Sixth Amendment violation had not occurred, is the reliability of the verdict in question? In other words, had the jury not heard the evidence they shouldn't have heard and been allowed to hear the evidence that they should have heard in the psychiatric testimony, is there a reasonable probability to undermine confidence in the outcome of the case? In my opinion, yes. You can't say, well, if these lawyers try the case again, you know, there's a reasonable possibility you get a different result. That has never been the test. It's only, do we have a lack of confidence? And what you do is, generally, you use the same factors you use in the harmless error analysis. You simply say, what are the errors, how did the errors affect the trial? And if you have, it's the truth-finding function. That's what I'm saying. If you have a failure of the truth-finding function, then you have a doubt as to the reliability of the verdict. And let me summarize it by saying this. Everyone in this courtroom has a different sense of what justice means. We all can disagree all day about what justice means with the definition. Can all disagree about whether the result here is just or not. But I think we can all agree that if the rules are followed properly, and the man is given the lawyer that he's supposed to have, and the jury hears the proper things, and if the rules are followed, that creates a result that we feel comfortable in, because that's the best we can do as humans. And that's a just result. And you don't have a question as to the reliability of it, because the rules were followed. You don't say whether guilty or innocent. Here, in my opinion, the constitutional rules were not followed by that lawyer, those lawyers, to a significant detriment of this man, and therefore there should be a reasonable question as to the reliability of the verdict. The errors here, General, were significant and profound. And that's why I think cumulatively this is a Sixth Amendment violation. That's the conclusion that a court has to make on the third prong, and that's the one I've reached.
Okay. And the court may well reach that or not.
That's the court's prerogative. I'm just a witness.
Right. Yeah. One other jury instruction issue, the moral versus legal wrongfulness. You agree, the attorneys, that we did discuss that, and that the state of the law, the instruction given by Judge Fishburne, was a correct statement of the law.
The judge quoted the statute verbatim. That is the law. There's no question about that. I think that there is at least a debatable argument as to whether the court goes further and said there is no other definition other than that. And I realize that appellate opinions say that. I've seen that more times than I can count. The question is whether or not that verbiage is to be given to the jury, that the law makes no definition of what wrongfulness means, it's up to you to decide, that sort of thing. So to answer your question, of course the judge quoted the statute verbatim. That was absolutely correct and proper. My issue is about whether or not the instruction that the law makes no definition of it. And the reason that I say that is because that is something you see in the appellate decisions. And General, you and I are familiar with the doctrine that just because an appellate court says something doesn't mean it's got to be given to a jury. And I keep going back to the Graham decision where they defined wrongfulness. And the Supreme Court said this: we note that we use the word wrongfulness in the place of criminality. So the rule requires an appreciation of the wrongfulness of conduct as opposed to its criminality. So you don't have to appreciate that it's criminal that you're doing. It may be wrongfulness in another sense, perhaps moral. That's an issue that can be raised on appeal at some later time. But I think that there's enough of an issue here that to say there is no definition, that is something that maybe the lawyers could have objected to preserve the issue, file a special request citing Graham. That's not for me to say. What you're asking me is that the judge instruct the jury correctly as it relates to the definition, without a doubt, 100%.
And in accordance with the pattern jury instruction book, which says that these are not written in stone, they can be modified and should be to fit the facts of the case.
I've quoted that, and we've all quoted that. The pattern jury instructions are just patterns, they're not the law. And then so, was the judge's instruction on that? Yes. But what that led to is exactly what happened when the jury comes back with that question. What does it mean? And then, you'd like tell them it means whatever you think it means. It's unguided thing. I'm suggesting that the lawyers could have filed a special request on that so that the issue would have been preserved. Probably there's enough issue there that they could raise it independently. I'm not saying that is a constitutional defect, not ineffective assistance of counsel per se. It's not objectively unreasonable. It should have been done to preserve the issue, probably could have been done otherwise. But,
And that was
that's
the
my
point-
opinion on it.
I'm sorry. I was going to say, and that was the point of my question, as far as that being ineffective assistance of counsel.
No, it was not. It does not under my reading of the law, that does not fall under the deficiency prong of the Constitution. So no. Should it have been done to preserve it? Maybe under best practices. But my opinion did not say that, and I still above that view.
Just
That
wanted to
is
be-
not something that
I just wanted to
caused,
clarify
yeah,
that
it's
part.
not ineffective assistance of counsel, in my view.
Just a moment, Your Honor, and I don't know if we've come to a time when the court reporter needs a break.
Is that a hint? You want a break for lunch? He's got things to do.
I was going to say, I saw the phone in his hand.
My son is sitting over there with one of my witnesses. I need to get back over there. So if we could just take a break and just keep going.
That's fine with me.
Yes.
Instead of that, can we take a 5-minute break?
All right, 5-minute break.
Thank you, Judge.